Supreme Court is giving Georgia, Pennsylvania, Michigan, and Wisconsin until 3 p.m. Thursday to respond to an election lawsuit filed today by the state of Texas. The suit arguing that those states violated the Constitution in the process of appointing presidential electors by unlawfully abrogating state election laws.
I want to talk about this Texas lawsuit, which now has other Republican states jumping in. It's a lawsuit that even Trump calls the big one. And it is striking for its constitutional precision and its constitutional sort of cleanliness. And what I mean is Texas doesn't try to document or lay out the empirical evidence for fraud. Other people are doing that. Texas makes kind of a core constitutional argument, which hinges upon the simple idea that the United States is a union of states. The states come together and make a sort of mutual pact with one another. And the terms of this pact, the contract itself, is the Constitution, which lays out the conditions of this union. Now, the Constitution says, Article 2, Section 1, very clearly that state legislatures will make the rules, the laws, that govern how electors are to be chosen. And the claim of Texas is that a number of these swing states, from Georgia to Pennsylvania to Michigan, Wisconsin, have violated their own state laws. They have sort of made up the rules as they went along. And governors or judges have taken it upon themselves the discretion to say, well, we're going to modify the law in this way. We're going to modify it in that way. And Texas's point is, you can't do that. Because by violating the Constitution and appointing perhaps different electors that would be chosen by a constitutional process, you're injuring the interests of Texas electors. You're redistributing, you may say, the constitutional balance of power. There's a second argument embedded in that, which is that if you change the laws in certain regions, but not others, of a state, you deny citizens equal protection of the laws. It's kind of like ultimately having two sets of standards, one which apply to Democratic areas and another that applies to Republican areas. Really glad the Supreme Court is taking a hard look at this, because nothing could be more central to the Constitution itself. And here I think, there's no question we've got liberal judges who are judges, in quotation marks, but they don't really respect the Constitution. They think the Constitution is some sort of living document and evolves their way. Well, I mean, we can adopt the same approach and say the Constitution is a living document, but happens to evolve our way. And this would make us kind of a lawless society, or a society ultimately not under the Constitution would sort of cease to matter. But for judges for whom the Constitution does matter, this Texas argument is one I think that commands very urgent and serious attention.